Grant Robertson.
Mr. Chair, thank you. And it's opportune because I also want to pick up and develop the ideas that the previous speaker was working on, in particular looking at, I see how pleased you are about that, Mr. Chair. It's great to have your endorsement. So in particular looking at the amendments to Schedule 3, and I'm looking here at Clause 11. Oh no, I'm coming to that, in Clause 11, which is titled Borrowers who are settlors of trusts. Now, it's very important to go back and recognise that all of the amendments in Part 1 of the bill relate to borrowers, or the vast majority of them, relate to borrowers who are offshore. So this is when you are in Australia and you still owe the money, but you're not there.
Student loan. Student
loans, that's right. Borrowers, student loan borrowers offshore. But in this case, Mr. Chair, we're talking about borrowers who are the settlers of trusts. That's the heading on Clause 11. This is an interesting conversation we're having here, but yes, I think we're on the same page, metaphorically and literally. And so, as my colleague has mentioned, there is an expectation inherent within this clause that we know the income of the borrower from the trust that they're getting. That's actually what the clause is based on, and the formula that my colleague mentioned that's in 11.4 and 11.5 are generated by knowing the income of the trust. That's essentially what lies at the heart of this clause. And that would be right if you were a New Zealand resident borrower, because if you're a New Zealand resident borrower and you have a trust, you have income tax obligations. Not if you're not in New Zealand. Not if you aren't a New Zealander. Changes that have been made in recent years, Mr. Chair, mean that if you are not if it's a trust where those who set it up are not New Zealand residents, they have no income tax obligations. None. Whatsoever. So here we are with student loan borrowers who are the settlers of trusts, a string of obligations put upon them which we can enforce, which Inland Revenue can enforce, because they know the income that that trust is generating, a tax return is returned, and then we can judge from that how much the borrower, student loan borrower, Mr. Chair, would be paying back. That's a fair system. Contrast that with the information that we have about other types of trusts. Foreign trusts where there is no information like that that could even be used to work out whether or not somebody owed money. And once again, we have our concern on this side of the House about the absence of the critical element of a taxation system, fair treatment. And New Zealanders should be proud in general of our tax system. It actually is robust and it does work well. But where deliberate decisions are made, as they were in a tax bill that went through this House in 2010, to create loopholes through which we, for instance, could zero rate a managed fund, we then create the opportunity for that to be exploited and unfairness to join in our system. And so, Mr. Chair, my question for the Minister in this regard is somewhat technical, but it is relevant, which is that at what point does somebody become a non-resident for tax purposes? Because if the issue that we know in terms of the setting up of trusts is that if you aren't a resident, that's where you can exploit the loophole. How long would a borrower who is the settler of a trust need to be away from New Zealand to no longer be considered a resident? And this is a serious question, Mr. Chair, because we are dealing with, in new clause of 11 here, exactly that kind of person, a person who has been in New Zealand.
Loan borrower.
That's correct, but in this case, Mr. Chair, it's a student loan borrower who's the settler of a trust. Pretty sure we're still on the same page. And so that student loan borrower, at what point after they have been away are they no longer considered a resident for tax purposes? Because this matters, Mr. Chair, when it comes to the question of who of their obligations as a settler of the trust, because we know those obligations are in fact different depending on whether or not you are a resident or a non-resident in New Zealand. Again, it's a question of basic fairness, and the reason I'm raising it with the Minister is that we do now know that a lot of young New Zealanders are spending longer away, having graduated from university with a student loan, and should they have structured their affairs in such a way that they are the settler of a trust, does the identity of, or can the identity of that trust change over time so that it effectively becomes a non-residence trust and therefore no longer subject to these obligations?
Nash.
Mr Chair, I would like to